Good afternoon, everyone, and welcome back to our weekly webinar series. Today, we are going to take up part 3 of NCLT Rules. In the past 2 weeks, we had done part 1 and 2 respectively. Also, we would like to share a good news with you. I think Anil sir will be able to share that with all of you, and we are extremely happy about that as well. So we will love to share that achievement with all of you. Over to Anil sir.
Thank you, Ankit. So I would seek your involvement in this NCLT rules, which may be the last part. We will try to take it a little faster. But however, I think there is one, because we'll actually try to give some recap and for the last part 1 and part 2. So first we covered the definitions, and then we saw this rule 11, and we also deliberated on some of the judicial pronouncements, which is basically the powers of the rule with the objective to meet ends of justice and also to prevent any of the process of the tribunal. That was rule 11. Tribunal for exemption, providing exemption from any kind of directions or order which was passed or any kind of dates. Then we also saw the powers of the tribunal for extension of time, and also the functions of president of the tribunal, registrar of the tribunal, the procedure, also the procedure of applications, then how the application would be presented. We also discussed the margin, how it will be bound, and then the caveat. We saw that the caveat is valid only for 90 days, and then we also saw the how and for what reason the interlocutory applications can be filed, which is normally called IAs. And then we also saw the how the replies and rejoinders can be filed, and then we also realized that it is all with the prior permission of the tribunal, that somebody can say file and reply and also the rejoinder. Then we discussed the complete procedure where the NCLT rules provides for formats. So the format 1 is for what would be the format of any application. The format 2 was if the application is admitted, the notice of admission. Then the format 3 was the in case of notice is not being served, then the form of advertisement. Then we also saw what would be the general heading, that is also provided in the rule in form NCLT form 4. NCLT form 5 is like notices to the third parties, the opposite parties. Then the affidavit also is provided in NCLT rule 6. So these are all kind of wakalatnama is also provided in NCLT 12. So we'll take it forward from now onwards, and I'll just share my screen and just give me a minute. Okay. So I'll just so Ankit, we were at the last time we left our part 2 at hearing of petitions or applications. As the tribunal, it is actually casted at the tribunal duty on the tribunal that the tribunal shall notify the parties the date and place of the hearing and the mode and manner of the hearing. Also, it is the tribunal's duty to notify whether the hearing will be virtual or it will be physical, and also time and the hearing date of the sitting of the bench. And so even the withdrawal of application is handled by section rules 44. It says that whenever a particular party wants to withdraw the petition, and it should be even before the hearing, he is required to file an application, and that application also would be heard and the other parties would also have a say. And there is a possibility that the other parties may say that the withdrawal should not be permitted. But however, in case the withdrawal is permitted, the bench also will decide how much cost has to be imposed for wasting the time of the tribunal. Then the rights of the parties to appear before tribunal, like as every party has a right to appear before the tribunal in person or through an authorized representative. Uh, then the wakalatnama would be given, or the memorandum of appearances would be given in form number NCLT 12. However, when there is a specific rule, because this is tribunal is regarding Companies Act, so in case the central government, regional director or registrar of companies or official liquidator, if they are the parties to any of the cases, then they may authorize an officer or an advocate to represent in the proceedings before the tribunal. And in case they authorize an officer, that officer should not be below the rank of junior time scale or company prosecutor. So then the tribunal also has the powers to uh, call upon the registrar of companies to submit information on the affairs of the company, and they can even seek further information which is available on MCA 21 portal or even in the physical files. The tribunal can even call upon the registrar of companies. And it is also provided in the Rule 45 that the no video or audio recording of the bench proceedings can be taken by the parties or their authorized representative. But however, now because since the proceedings are now virtual, and virtual proceedings are like anyone can take a video on of what is happening and that kind of scenario, which is the non-compliances are being done. And however, the rules say that no video or no audio can be recorded. Then like in case on the date fixed and on the venue fixed, in case the applicant does not appear, then in that case, the tribunal will have two options. One is to dismiss the application for default or hear and decide it on merit. So when the applicant doesn't come, that means there are two options available with the uh, tribunal. And where the in case the application can be dismissed for default, the application can be dismissed for default because the applicant did not appear for hearing. And then in case it is done, in case it is dismissed, then the applicant can file an appeal within 30 days from the date of dismissal and satisfy the tribunal that he was prevented by sufficient reason for his non-appearance. And then, however, in case the tribunal decides to fix the case or dispose of the case on merit, then the tribunal doesn't have any power to reopen that. So in case it has already been decided on merits, there is no power to reopen. However, in case it has been dismissed, then the applicant will have to file another other application within 30 days. So we could find one judicial pronouncement on this Rule 48, which is Kumar Industries partnership firm through its partners versus Birulal Lalchand Chopra versus Avid Organics Private Limited. So this is an NCLT Ahmedabad case, September 20. And in this particular case, the application was filed, it was dismissed, and finally the advocate said that it was not the fault of the petitioner, it was the advocate's fault. The even this when this the application which was filed, that was also not filed within 30 days. However, the advocate of the petitioner could present some of the evidences that it was he who was responsible. So based on various Supreme Court judgments, that on account of the fault of advocate, the applicant should not suffer. So therefore, based on various Supreme Court decisions, this matter was also decided by the tribunal, saying that the dismissal order was reopened. And it was not the order passed on merit, but it was basically the order dismissal order, which was reopened. Moving forward to section 49, ex parte here, hearing and disposal. So first we saw 48, where the applicant could not come and attend the hearing. Now we are saying that the respondent could not come and attend the hearing. So when the respondent do not come, then the tribunal will have three options. One, adjourn the hearing. Two, hear and decide the petition, or heard ex parte. Like again, heard ex parte. So when the petition or the application has been heard ex parte against a respondent or respondent, such a respondent or respondent may apply to the tribunal for an order to set aside. And if the respondent or respondent satisfy the tribunal that notice was not duly served, or that he or they were prevented by any sufficient cause from appearing when the petition or the application was called for hearing, the tribunal may make an order setting aside the ex parte hearing as against him, or them upon such terms as it thinks fit, provided that where the ex parte hearing of the petition or application is of such nature that it cannot be set aside as against one respondent only, it may be set aside as against all or any of the other respondents also. So the ex parte decisions, the tribunal has full power to recall, and the tribunal can set aside their own ex parte decisions and can hear it again. Here we can discuss against under Rule 49 sub Rule 2 the Hectard Infotech Private Limited versus Secutre Global Private Limited, again March 2022 NCLT appeal. And the question of law in this appeal was whether the adjudicating authority, that means NCLT, is fully competent to recall ex parte order in exercise of its jurisdiction under Rule 49(2) of NCLT Rules 2016. Now, the background of the case is such that the application was filed by the CD before NCLT to recall orders which the applicant was set ex parte. NCLT dismissed the application for a warrant of jurisdiction. In appeal, the appellant contended that the ex parte order passed by NCLT was an order without service of notice on the corporate debtor, hence deserves to be recalled. So Rule 49, sub Rule 2 of the NCLT rules specifically deals with the proceedings which have been ex parte heard and disposed of. So this was the background of the case and observation of the NCLT. Let's see. And the NCLT said that the NCLT committed error in holding that appellant was asking for review of the admission order, forming an opinion that Rule 11 of the NCLT rules cannot be used seeking recall or review of the order. That's not correct. The CD was seeking to recall the ex parte order, which powers were specifically conferred on the adjudicating authority under Rule 49, sub Rule 2. When power is specifically conferred under the rule, there is no question of exercising any review jurisdiction in the facts of the present case. So therefore, the adjudicating is fully competent to recall ex parte order in exercise of its jurisdiction under Rule 49. So therefore, the appeal was allowed. So that means the respondent did not appear, ex parte order was passed, and now when the again applicant go to appellate authority, the appellate authority decided that the NCLT committed an error in holding that the applicant was asking for a review of the admission order. So it was allowed by NCLT. So now even if somebody miss a hearing, so even if the order is passed ex parte, he need to give evidences that yes, this particular decision has been wrong and I have few more documents. So the benches normally will cooperate. That's why I understand. So anything, Ankit, that you would like to add here, where the ex parte, there are two kinds of ex parte that we have discussed. One, where the applicant is not appearing, and the other is when the respondent is not appearing.
No, I think it's fairly clear from whatever you shared, and the case laws also make it very, very clear on how the NCLAT NCLT deal with such situations.
Yeah.
Um and we see that the courts are pretty patient whenever this kind of a non-appearance happens, and I think that's something that we've seen in almost all cases with NCLT and CLAT.
I think you are very right in saying that the courts are very liberal and they don't increase their workload by passing orders and then again kind of allowing them to uh, proceed on merits.
Yeah.
So we have this suspended management of J Polypack Private Limited versus SGV Foils Private Limited, and again September 21 judgment from NCLAT. So in this NCLAT judgment, the question of law which could be framed was as whether learned adjudicating authority in an exercise of power uh, under Rule 49 sub Rule 2 of the NCLT Rules 2016 can cite an ex parte order for initiating a corporate insolvency resolution process under Section 9 of the IPC. Can set aside the ex parte order for initiating. Because earlier we have seen once the order is passed, the tribunal doesn't have any power to review it. However, the powers that it was mentioned in the Rule 49 that we could see that in Rule 49 an application can be made within the stipulated time, and once that application is made, then the bench will hear and will decide whether they would allow the hearing now, and that once they allow the hearing, that means the uh, ex parte order is withdrawn. So the application under Section 9 was admitted, and the suspended manager filed an application for setting aside the ex parte order, and that ex parte order was also under Section 424 of the Act Rule 911 of the NCLT Rules, stating that the corporate debtor has not received the notice. When the COC was constituted after filing of a forcible application for setting aside ex parte order of admission, NCLT disposed the application for setting aside the ex parte order on ground that it belated stage. So therefore, the adjudicating authority is unable to use power under Rule 49 of the NCLT Rules 2016. So the ex parte order cannot be recalled. And in case the action has actually been taken, COC was constituted, so that kind of comfort is still there. Now, in this case, the observation of the NCLAT was the before constitution of COC, if the AA is satisfied that the notice was not duly served on the corporate debtor, then the adjudicating authority may make an order for setting aside the ex parte order for initiating CIRP upon such terms as it think fit. However, after constitution of COC, after constitution of the COC, the adjudicating authority can set aside even ex parte admission order, and in such a situation, the corporate debtor has to file. The corporate debtor has to file the appeal under Section 61 of IBC. In fact, the facts of the case, the application under 9 was on 27th of May 2020, and the appellant filed the application for setting aside ex parte admission order on 16th of November 2020, 6th of November, whereas the COC has been constituted thereafter on 20th of November. So in such a situation, before the constitution of COC, the learned AA can consider the application for setting aside the ex parte admission order, but after constitution of the COC, the learned adjudicating authority cannot, in exercise of powers under Rule 49(2) of the NCLT rules, set aside the ex parte admission order. The Learner A has passed impugned order after constitution of the COC, that is 23rd of March 2021. Therefore, no illegality in the impugned order. So, COC was constituted. The application for setting aside ex parte admission order that was received on 6th of November, but the COC was constituted after that. But when it came for the hearing, by that time, the committee was constituted. So, in case of delay, and RP has to constitute the committee. So once the committee is constituted, then the difficulty is that the ex parte order would not be withdrawn. It cannot be withdrawn. Little dicey situation, but then yes, we have to accept such kind of, I understand. Now, I think we move on to a completely new subject, which is a registry to send certified copies. The registry shall send a certified copy of the final order passed to the parties concerned, and that is free of cost. That is the first requirement. Then the certified copies may be made available with the cost as per schedule of fee in all other cases. So the parties will get the order free of cost, and any other copies in case somebody asks for it, then it will be costing, and that schedule of fee is already provided, and it will be available on fee, certified copied. Now, this Rule 50 again has a litigation which says the Hasmukh N. Shah and Associates versus Victoria Entertainment Private Limited, December 2021 case, and it is from NCLT Delhi. Now, let us see, the question of law is that the whether limitation to file appeal under Section 61 cannot be treated to be under suspension till free of cost copy is received by party, as enjoined by NCLT Rules 1250. Now, the appellant somehow was delayed, and now appellant is trying to find out whether this limitation to file an appeal can be treated as extended till the free copy is received by the party. So let's see what NCLT say about it. The facts are, the judgment date is July 2018. The appellant applied copy of the order twice. Firstly, in January 19. January 19 means the 6 months delay in application, and secondly, again after 6 months. So first delay by 6 months, second delay by 6 months. Certified copies was ready and issued on 29 itself. So when the second time application was given, the certified copies were available. So the appeal under Section 61 was filed again after about 1.5 months from the date when the certified copies were available. Now, the NCLT, let's see what says. NCLT says that the Rule 50 is a procedural rule which obliges the registry to send a certified copy of the final order passed to the parties concerned free of cost. So the rule enjoins the duty of the registrar to send the certified copy of the final order passed by the parties in concerned free of cost. Then, and when Section 61 of the Code is read with the Rule 50 of the NCLT rules, it cannot be said that the limitation in filing of an appeal under Section 61 cannot begin to run unless free of cost copy is sent by registry and received by the party. So the limitation to file appeal under Section 21 cannot be treated to be under suspension till the free copy is given. Similarly, the Rule 50 deals with the procedure, and Procedure 50 and Rule 50 is part of the procedure law, which obliges the registry to send the free copy. The scheme of limitation for filing appeal as delineated by Section 61 does not give any scope to the submission that the limitation to file an appeal under Section 61 shall not begin till the cost under Rule 50 is received. Therefore, Rule 50 of the NCLT rules cannot be read to be a rule governing the limitation according to the appeal have been filed after the expiry of limitation. So this is what was the uncleared opinion. Now we move on to the substitution of legal representatives. Rule 53 says, whenever somebody dies or adjusts insolvent, then he would not be appearing and he would not be participating, but the proceedings shall not abate. That means that the proceedings shall continue, it shall not abate, and the executors or administrators or other legal representative of the parties and shall be against the assigned receiver of liquidity as the case may be. So in case of death of the party during the pendency of the proceeding before the tribunal, the legal representative of the deceased party may apply within 90 days of the date of such death for being brought on record. Where no petition or application is received from the legal representative within the period specified, the proceedings shall abate. So the proceedings cannot continue if the substitution of the legal representative is not done. In case the substitution is not done, the proceedings shall abate, provided that for good and sufficient reasons shown, the tribunal may allow substitution of legal representatives of the deceased at any time before the disposal of the petition on merit. But however, it can be misused also, that somebody is expecting that some big claim can be can be passed against them. But however, in case the time given is 90 days, and in case within 90 days the substitution of legal representative is not done, then it would be any kind of, to my understanding, then the tribunal can proceed. The tribunal can actually, the petition can be considered as disposed of, and that too without hearing them. So Fakru Nisa Fahim and others versus Hira Multi Construction Ventures Private Limited, June 22 case. Ankit, you can just read June 22 case for the audience.
So the fact here is that the deceased Dr. F. Muhammad, who was the sole petitioner in instant company petition, passed away on 5th May 2021 during the pendency of company petition filed under Section 59 of Companies Act, alleging illegal transfer of shares without due procedure of law. Petitioners claiming to be legal heirs of deceased Dr. F. Muhammad, the sole company petitioner, filed an application praying to implead them as petitioners number 2 to 6 and to amend cause title of petition to show them as petitioners numbers 2 to 6 in the petition. So the respondents resisted the IA, contending that the petitioners are required to obtain succession certificate under Succession Act 1925. Further, as per Rule 53(2) of the NCLT Rules, an application for bringing legal heirs is required to be filed within 90 days.
Yeah.
So let's go. Rules observations here were that Rule 53 of NCLT Rules expressly provide for impleading the legal representatives in case of a party to a proceeding before a bench dies during the pendency of the proceedings. This express provision does not end
before a party.
Before a party dies, yeah.
Yeah.
This express opinion does not envisage filing of succession certificate by the legal representative heirs or the company petitioner in order to maintain the petition to implead them as legal heirs. Therefore, the argument that the present petition application shall accompany the succession certificate test, this IA is not maintainable or is unacceptable. So accordingly, the IA was allowed. So basically, very clear that the respondents were trying to delay the matter through this requirement, because the succession certificate application, I think depending on where you're applying it, would take anywhere between 6 months to 1 year's time. So that was perhaps the idea behind the resistance from the respondents.
The tribunal also has powers to appoint valuers. Wherever they find that they need some assessment of the value, they will appoint valuers. So Ankit, this valuation under the Companies Act, because this would be, what we are saying is that there are two parts of tribunal. One is that in case they need to get an evaluation in a case under the Companies Act, And secondly, in case they need to get a valuation in a case under IBC, in IBC they are supposed to appoint registered valuers. And for however, for Companies Act, which is
Companies Act,
considered as
so the registered value framework is coming from the Companies Act, Section 247 of the Companies Act. So any valuation required under the Companies Act is also requiring registered valuers. So there is no gap there. They're both
so
saying the same thing.
yes, yes. I think Rule
The
54, yes,
Rule
please.
54, Rule 54, I'm not sure I'm aware of a judgment where that was discussed that in case the valuation is the matter of scrutiny in NCLT, where the petitioner files a petition and says that the valuation has not been done correctly,
Hmm.
and therefore there is certain gap in it, and he talks about. So there is this case. I think it was Indian Bank versus some. It was a 2020 case where the court said that there are two distinctions here. One, the valuation report has to be robust enough to stand its own ground. Secondly, in case somebody wants to challenge the valuation in the court, he has to point out at major errors, major issues in the whole process. He can't just say that the valuation is wrong. So these are the two interpretations there. And then the court did say that it has the jurisdiction to get a valuation, independent valuation done in case there is some fault which is noticeable in the valuation exercise. So I believe that also is further supported by Rule 54.
It is also said in Rule 54 that the remuneration, whatever it would be payable, and that can be determined by the tribunal and to be paid by the manner as may be specified by the tribunal. So tribunal may say that which party will bear the cost of the evaluation, or so these are all the decisions will have to be taken by tribunal, but I think it has to be paid either collectively or any one person, depending upon the need, how
At,
the
at AAA valuation, we have done multiple such assignments. So where does the court get this done? So they say there is a fight between two brothers with respect to a company where they're not able to achieve and understand that okay, what is the value that they want to exchange. So there we have done a valuation. In another valuation, there was an allegation that the minority interest wanted to sue the majority shareholders, talking about how the a certain siphoning off has happened. So again, there and we were appointed as an assessor. So those kind of appointments have happened.
So in case we are now talking about ourselves, so we can even also share our happiness, also share our landmark, because see, everyone may be knowing that on 28th of September, the IBBI came with a new law, new regulations, where the IBBI said that the instead of IBBI said that the IPE can also apply for registration as IP. So that means that once the IPE can also function as IP, and therefore the appointment of IRP, RP, liquidator, bankruptcy trustee, all this, all this can be done to a company or to a firm. Like for suppose we have AAA Insolvency Professionals LLP. So now whatever orders will come, and in case the creditors have opted for, if the creditors have opted for the institutional IP, then the uh, in, then the company like AAA Insolvency Professionals LLP can be appointed as IRP, RP, liquidator, bankruptcy trustee. However, the IPE will uh, notify that who and which partner will conduct the process. So this is what the new law has been made, and we got the registration because since this new law was circulated on 28th of September 2022, and we in fact actively did our part, and we became the institutional first institutional IP under IBC. So Ankit, you can take up the next part. This is the effect of non-compliance.
So the Rule 54 says failure to comply with any requirement of these rules shall be not invalidate any proceedings merely by reason of such failure, unless the tribunal is of the view that such failure has resulted in miscarriage of justice. So somebody can just point out to the rules and say that, see, this rule was not followed. So that's the power that allows the tribunal or the judges to decide if that non-compliance was material enough to provide any, to cause any injustice or not. So, notwithstanding anything to the contrary contained in any rules or regulations, so no order or direction imposing a penalty under the act shall be made unless the person or the company or a party to the proceedings during proceedings of the bench has been given a show cause notice and reasonable opportunity to represent. So this is the basic law of giving the person an opportunity of being heard. It is a rule for natural justice that we learn, or any person who has studied law understands that this is something which is supreme, the law of natural justice or opportunity of natural justice. In case the bench decides to issue show cause notice to any person or company or any party to the proceedings, as the case may be under sub rule 1, the registrar shall issue a show cause notice giving not less than 15 days, asking for submission of explanation in writing within the period stipulated in the notice. Then it says that the bench shall, on receipt of the explanation and after oral hearing, if granted, proceed to decide the matter of imposition of penalty on the facts and circumstances of the case. So, the show cause notice, it has to go through the proper process. Then this one is issuance of orders and disposal of cases. Rule 60 here talks about matters relating to judgments of orders of the tribunal. So it says that once the final text of the judgment has been approved and adopted, the judgment shall be signed and dated by the president or the concerned members or member and the registrar, and shall contain the names of the members who have taken part in the decision. Then any member differing as to the grounds upon which the judgment was passed or some of its conclusions or dissenting from the judgment may append a separate or dissenting opinion. So in case the members who have heard the case are equally divided in passing the order of judgment, then the president shall constitute a bench as referred to in subsection 5 of section 419 of the Act. So this would be valid where, say, there are two members to a bench. So now we understand that normally it would be one member of the bench would take the responsibility uh, of of uh, of making the order, and then the other member would make some additions in case he wants to. That's how the NCLT judgments work. In the recent judgment with respect to the Supreme Court judgment, we observed how the dissenting opinion is also made part of the part of the judgment. So it was a 3-1 judgment which was passed in case of the recent EWS quota ruling from the Supreme Court. So there we saw that how three judges passed an order, and then the two judges who were dissenting passed their own order, and both the parts were part of the final order. The tribunal may, as its direction, permit any person or persons, including the professionals and professional bodies, to render or to communicate views to the tribunal as amicus curiae on any point or points of legal issues as the case may be assigned to such amicus curiae. We understand this also happens very frequently. We have seen this happening, that whenever a new regulation or a new law comes in, or the Supreme Court, when insolvency law came in, at many instances appointed a amicus curiae to assist the court in understanding and in taking up the case. The tribunal may permit amicus curiae to have access to the pleadings of the parties, and the tribunal shall enable the parties to submit timely observations on brief provided by the amicus curiae. The tribunal shall be at liberty to direct either of the parties or both the parties to the proceedings involving a point on which the opinion of the amicus curiae has been sought, to bear such expenses or fee as the case may be ordered by the tribunal. The judgment and any appended opinions shall be transmitted to the parties and to amicus curiae. Recusal. So Rule 62 talks about, for the purpose of maintaining the high standards and integrity of the tribunal, the president or member of the tribunal shall recuse himself in any cases involving persons with whom the president or the member has had a personal, familiar, or professional relationship, In any cases concerning which the president or member has previously been called upon in another capacity, including as advisor, representative, expert, or witness, if there exists any circumstances such as to make the president or the member's participation seem inappropriate. So the president or any member recusing himself may record reasons for recusal, provided that no party to the proceedings or any other person shall have a right to know the reasons for recusal by the president or the member in the case. So,
But
yes,
we have
that
seen
is
many,
possible.
we have seen some cases where the members recuse themselves and because of some interest which they have in that case. So
Mm.
that's also something which is important.
So,
Service of,
yeah,
yes,
please go
yes.
ahead. You can go ahead.
Service of process, appearances of respondent and objections. This is like issue of notice 105 rule. It says that the all the documents and all the copy of this affidavit shall be served upon with the notice on the other side and show the date of presentation. What is for the when this particular petition was presented, the name of the authorized representative, and the dusty copy can also be submitted. The affidavit of service would be submitted. So these are the issue of notice. We'll do because you see every day. So how I think the summon like 106, then we can actually talk about this. So whenever summons or notice is ordered by private service, the appellant or applicant or petitioner, as the case may be, unless already served on the other side in advance, shall arrange to serve the copy of all appeals or petitions or applications by registered post or courier service and file affidavit of service with its proof of acknowledgement before the date fixed for hearing. That's the notice which is issued to the other parties, and that has to be issued by registered post or courier service, and the affidavit will be filed before the date of fixed hearing. Steps for issue of fresh notice. Any notice issued under Rule 105 is returned unreserved, and then the fact that the reason thereof shall be notified immediately on the notice board of the report of the registry. The applicant or the petitioner or his authorized representative shall within 7 days from the date of notification take steps to serve the notice afresh. So any notice coming back, it is the duty of the registrar to put that notify on the notice board of the registry. People will take note of it, and in case they see that their notice which was served, that the registrar is saying that has come back, so they would actually uh, within 7 days from the date of notification takes further steps to serve certain notices afresh. Like in case the consequence of failure to take steps for issue of fresh notice, but after a summons has been issued to the other party and the return answered, and the applicant or petitioner or appellant, as the case may be, fails to take necessary steps within the period ordered by the tribunal from the date of return of the notice on the respondent, the registrar shall post the case before the bench for further direction or for dismissal of the non-prosecution. So non-prosecution is something which is considered to be that applicant is not uh, applicant is not interested now. Therefore, applicant is not doing the requisite things. So that is also called non-prosecution from the appellant side. Yes, Ankit, you can go ahead.
So, default of appearance of respondent and consequences. Uh, so it says that where the respondent, despite effective service of summons or notice on him, does not appear before the date fixed for hearing, the tribunal may proceed to hear the appeal or application or petition ex parte and pass final order on merits. So, provided that it is open to the tribunal to seek the assistance of any counsel as it deems fit in case the matter involves intricate and substantial questions. Filing of objection by respondent, form and consequences. So the respondent, if so directed, shall file objections or counter within the time allowed by the tribunal. The objections or counter shall be verified as an appeal or petition, and wherever new facts are sought to be introduced with the leave of the tribunal for the first time, the same shall be affirmed by a supporting affidavit. The respondent, if permitted to file objections or counter in any proceeding, shall also file 3 copies thereof after serving copies of the same on the appellant or petitioner or their counsel on record or authorized representative. Next one is about fee on petition or appeal, process fee, and award of costs.
We'll actually the fee part because if there is a fee which there is a schedule of fee. So in respect of even interlocutory applications, also it is the payment has to be made by way of bank draft drawn in favor of the payment accounts office, Minister of Corporate Affairs. However, it has actually now been open for even online payment. That has also. So these are the various fees which are for various matters under the Companies Act. So that we are going to skip. So this is the inspection of record is something that you can take up again.
So here we talk about the parties to any case or their authorized representative may be allowed to inspect the record of the case by making an application in writing to the registrar and by paying the fee prescribed thereof. Subject to such terms and conditions as may be directed by the President by a general or special order, a person who is not a party to the proceeding may also be allowed to inspect the proceeding after obtaining permission of the registrar in writing. So these are two systems through which one can inspect the records of the case with the NCLT. So this might be useful where maybe I can imagine that the party has appointed an advocate and the advocate is not available due to some circumstances. He's not able to share the record with the new advocate or the new counsel.
Yeah,
So in those cases, an inspection of the record should allow the party to the case to access all the documents on record at NCLT.
right.
Then grant of inspections, inspection of records of a pending or decided case must before the tribunal shall be allowed only on the order of the registrar.
So this power has also been given to the
Registrar.
registrar.
So Association of Agreed Workmen of Jet Airways versus Jet Airways. So this is an NCLAT matter, 20th January 2022, fairly recent.
The question of law in this
So here we say
the the question of law in this jetway airways application was whether the resolution plan after it being approved by AA continues to be confidential document so as to deny access to any of the claimants in view of Rule 114 of NCLT Rules 2016, which deals with inspection of record. Now, then in this case, it was held by the NCLT that the resolution plan is a document, and once the resolution plan is approved, then it becomes a public document. Therefore, it would be open for inspection. That's what it was decided. So I think we have said that the resolution plan does not remain a confidential document uh, after it is made part of the record or proceedings of the adjudicating authority. So that's what it was. This judgment was like this. The observation of NCLAT was when inspection is permitted of record of the AA under Rule 114, the inspection can very well be made of the resolution plan, which is part of the proceedings before the AA. Further, as per Rule 117, sub Rule 3 of the NCLT Rules 2016 provides that not note of any record can also be taken in pencil by a person inspecting the record. So in fact, I read that the process of taking some notes from the records, so that when they will ask you to sit and take inspection, they will not allow you to carry any pen. They will only ask you to keep a pen, paper and pencil in your hands so that you can take some notes whenever you read through or whenever you inspect the records. So that's what is the pencil is only allowed, and it has to be under supervision of any of the officials of the bench. Ankit, the application for grant of inspection you can read. Inspection, this is again regarding the inspection only, but then yes, you can say.
so the application and inspection of record under sub Rule 1 and 2 of Rule 114 shall be presented at registry between 10:30 a.m. to 3 p.m. on any working day and 2 days before the date on which the inspection is sought, unless otherwise permitted by the registrar. The registry shall submit the application with its remark before the registrar, who shall, on consideration of the same, pass appropriate orders. Inspection of records of a pending case shall be not ordinarily be permitted on the date fixed for hearing of the case or on the preceding day. So
This is
basically,
what I
these
was
rules are
discussing.
very practical. Yeah.
But this is, I was discussing mode of inspection, that it has to be done between 10:30 and 12:30, and then thereafter 2:30 to 4:30. These are the two time slots for
So
the
there shouldn't
inspection.
be any dislocation, mutilation, tampering, or damage to the record.
Yes, yes,
Then, of
yes.
course, you're talking about he should not make any marks on the paper and so on.
You
So
can
it
only
should be
take some
only,
notes, and that too with pencil.
yeah, makes sense. And a lot of, I think, practical experience has gone into these rules where
Yes,
all the
yes.
difficulties have been put into these rules itself.
Yeah.
Appearance of authorized representative. So no legal practitioner or authorized representative shall be entitled to appear and act in any proceeding before the tribunal unless he files into tribunal wakalatnama or memorandum of appearance, as the case may be, duly executed by or behalf of the parties for whom he appears. So yes, there has to be a wakalatnama. Consent for engaging another legal practitioner. So, a legal practitioner proposing to file a wakalatnama or memorandum of appearance, as the case may be, in any pending case of proceeding before the tribunal in which there is already a legal practitioner or authorized representative on record, shall do so only with the written consent of the legal practitioner or the authorized representative on record, on or which or when such consent is refused, with the permission of the tribunal after revocation of a wakalatnama or memorandum of appearance, as the case may be, on an application filed in this behalf, which shall receive consideration only after service of such application of the consul. So, appearance of authorized representative. Every affidavit shall be titled as before the National Company Law Tribunal, followed by the cause title of the appeal or application or other proceedings in which the affidavit is sought to be used. So the affidavit has to talk about which matter or which forum it is prepared for. Affidavit shall conform to the requirements of Order Order 11, Order 19, Rule 3 of Civil Procedure Code. Affidavit shall be sworn or affirmed before any advocate or notary who shall affix his official seal.
So the affidavits also should be sworn and affixed before an advocate or notary.
Yeah.
So advocates are doing, in fact, most of these cases, who shall affix his official seal.
So affidavits of illiterate usually challenged persons. So that's a special provision that form NCLT 14. So it says that where an affidavit is sworn or affirmed by a person who appears to be illiterate, visually challenged, or unacquainted with the language in which the affidavit is written, the attester shall certify that the affidavit was read, explained, or translated by him or in presence, and then he makes his signature or mark in the presence of the attester. So there is a form called NCLT 14. If the deponent is not known to the attester, his identity shall be testified by a person known to him, and the person identifying shall affix his signature in token thereof. So there is a possibility that the attester may not have any documents to prove that he is the same person. So this can be done. Document accompanying any affidavit shall be referred to therein an annexure number, and the attester shall make the endorsement thereon that this is the document marked, putting the annexure number in the affidavit. So the attester shall sign therein and shall mention the name and his designation. Disposal of cases and pronouncement of orders. So on receipt of an application, petition, appeal, etc., the tribunal, after giving the parties a reasonable opportunity of being heard, passes such orders thereon as it thinks fit, provided that the tribunal, after considering an appeal, may summarily dismiss the same for reasons to be recorded if the tribunal is of the opinion that there are not sufficient grounds for proceedings therewith. Operative portion of the order. So all orders or directions of the bench shall be stated in clear and precise terms in the last paragraph of the order. So it's important that the last paragraph is a summary para. It is that would give some standardization to the orders. Power to impose costs. So tribunal may in its direction pass such orders in respect of imposing costs on the defaulting party as it may deem fit. Pronouncement of orders. The tribunal, after hearing the applicant and respondent, shall make and pronounce an order either at once or soon as thereafter as may be practical, but not later than 30 days from the final hearing. So every order of the tribunal shall be in writing and signed and dated by the president or member. A certified copy of the order passed by the tribunal shall be given to the parties. Tribunal may transmit order made by it to any court for enforcement. An application made by either of the parties to the order or suo motu. Every order or judgment or notice shall bear the seal of the tribunal.
So that means that whenever we see that the order is reserved, so it means the application is reserved for order RFO. So that can only be RFO for not later than 30 days. So we have seen that in some cases where the tribunal is not able to pass an order within 30 days, then they at times rehear the case. So
So
the
the final hearing is changed by
yeah.
them to make it compliant with this regulation or this rule. Pronouncement of the order by any one member of the bench. So any member of the bench may pronounce the order for and on behalf of the bench. So when an order is pronounced under this rule, the court master shall make a note in the order sheet that the order of the bench consisted of the president and members was pronounced in open court on behalf of the bench. Rule 150, Shaji Purushothaman versus Union of India, Madras High Court Judgment 2020, March 2020.
So this judgment is also on the
So here it says that the petitioner got the certified copy of the order within 7 days from the date of pronouncement. As such, it cannot be said that there has been that he has been put to serious prejudice on account of non-uploading of the information relating to pronouncement of the order on 21/2020 and non-indication of the same in the cause list. Coming to mandatory nature of NCLT rules, more particularly rules 150 and 153, in the light of settled legal position that consequences may arise on account of non-adherence to the timeline procedure have not been indicated in the said rules, it can be considered to be only directory. So it is settled legal dictum that when a public functionary is required to perform a public function within a time frame, the same will be held to be directory unless the consequences thereof therefore are specified. Admittedly, the consequences that may emanate is to the non-adherence infraction of the rules have not been indicated in the statutory rules. Hence, the impugned common order cannot be set aside on that ground. So that's the basis through which they said that no, even if there is a slight non-issue with respect to the time frame, the order still remains valid. So you can't take that ground to challenge the order.
so therefore any kind of provisions where the public functionary is required to perform a public function within a time frame, that will always be considered as directory. So that's what is the observation of High Court. That's clear. I mean, let's see this, what it says.
So this is Ergomax India Private Limited versus the Registrar National Company Law Tribunal, September 21, NCLT, Chennai.
Yeah,
So,
NCLT.
whether an order judgment of a tribunal which is not pronounced at all is a nullity in the eyes of law. So a company petition was listed before the AA on 7/12/2020 under the caption for clarification, and an interim order was passed by which the matter was adjourned to 11/12/2020. On 11/12/2020, the matter was listed under the head for hearing clarification. The AA heard the matter and orders were reserved, but the interim order of 11/12/2020 was not uploaded on the NCLT website. Later, it was found that the order was pronounced on 7/12/2020 itself. There was no communication received by the appellant in regard to the pronouncement of the order, which was received by the AA. If an order judgment is delivered by tribunal ignoring of rules, then it will result in untold hardship, misery leading to a miscarriage of justice. So the fact that matter was heard in 11/12/2020 by AA, by no stretch of imagination, the final order of AA would have been pronounced on earlier date on 7/12/2020. Further, the final order dated 7/12/2020 was not found on the NCLT website, and only later it came to know on 6/2/2021. Then in law, it was held that the impugned order was never pronounced by the AA. So as per the judgment passed by the High Court of Bombay in Kamal case, saying held that Rule 150 of NCLT rules provides for pronouncement of order. Rule 151 of the rules pertain to pronouncement of the order by one member of the bench. As per section 150 section 5 of the NCLT rule, every order or judgment or notice shall bear the seal of the tribunal. So I think it is as per the rule 150. Yeah. Observation by Honorable Inclad, there being a significant omission in regard to the pronouncement of an order a pronouncement of an order by tribunal and the pronouncement being an essential judicial act, and hence it is declared nullity. So it was basically said that it is that order would not be understood to be an order that was passed.
So therefore the appeal was allowed, no?
Yeah.
So this is the okay.
So 152, authorizing any member to pronounce order. So the member of the bench who heard the case are not readily available or have ceased to be members. So the president may authorize any other member to pronounce the order on his behalf after being satisfied that the order has been duly prepared and signed by the members who heard the case. Then the order pronounced by the member so authorized shall be deemed to be duly pronounced. The member so authorized for pronouncement of the order shall affix his signature in the order sheet of the case stating that he has pronounced the order as provided in this rule. So in the order, if the order cannot be signed by reason of death, retirement, or resignation, so there is a possibility that the order is prepared. So in that case, the court can allow or authorize somebody else to sign that order. So all I think rules coming from practical scenarios or possible practical scenarios. Enlargement of time, so where any period is fixed by any by or under these rules for or granted by tribunal for doing any for doing of any fact or filing of any document or representation, the tribunal may, in its discretion from time to time, in the or interest of justice and for reason to be recorded, enlarge such period, even though the period fixed by under these rules is or granted by the tribunal may have expired. So the time can always be extended under that rule. Rectification of orders, so any clerical or arithmetic mistake, it can be corrected by the tribunal on its own motion or on application by any party by way of rectification. So any application under Rule 1 may be made in form number NCLT 9 within 2 years from the date of final order for rectification of the final order.
I think there is a form also, form number NCLT 9, which is required. And when we recall, rectification of order like clerical or arithmetic mistake, even under the Income Tax Act, that section is 154. And here the rule is 154.
General power to amend. So tribunal may, within 30 days of the date of completion of pleadings and such costs or otherwise that is may think, amend any defect or error in any proceeding before it, and all necessary amendments shall be made for purpose of determining that. Plasticine India. So let's try and understand what was the judgment here and take it.
Ahmedabad judgment, October 2019.
So the background of the case was the applicant was filed with a successful resolution applicant under IBC for making amendment in the prayer clause, wherein due to inadvertence certain prayers were left out which were to be incorporated. So let's understand what happens. So the applicant by this application is seeking amendment in the prayer, therefore exercising the powers under section 65 of the IBC. The application is allowed. The applicant is directed to carry out necessary amendments in prayer clause. So it was permitted. So certain format of order. So all orders shall be neatly and fairly typewritten in double space on one side only, on durable foolscape folio paper of metric A4 size. So all this is there. A4 has been adopted here, but I think double-sided printing has not been. So maybe we will see that also someday.
Right.
So that's about it. I believe we are also past our time, and we have a few questions. Let's just quickly run through that. Let me understand if there are any important questions. Is there any method of numbering the pages and extras in case of applicant, rejoinder, etc.? So R1, R2, etc., or A1, A2, etc. I think that would be based on the code that you're dealing with. There can be some format that is followed by the NCLT itself. Um, please explain the judicial and technical members functioning. Maybe this is something we can share our practical experience of.
Now, you see, the judicial, as far as the powers are concerned, the judicial member and technical member can collectively make a bench. And they, once the bench is constituted like this, they both has to sit, hear a case, and then dispose it off. However, the president of the tribunal has the power that they can even authorize a single bench, a single member bench also. But in NCLT, it was only a few times that the single member bench was authorized. Otherwise, the single members are not authorized. And also, in case the single bench would be, and that single bench would be of a judicial member. And however, the single bench of a technical member is not possible. So the technical member is considered to be a person who has the knowledge of the technical part of it, whereas the judicial member is more of the uh, judicial processes and procedures, is something which is supposed to be a person who has that experience and knowledge, whereas the technical member can be a person who has the knowledge of the relevant field. That's what it is, the technical and yes.
All right, then. Thank you, everyone, for
So I think
being
we
part
have
of
to share.
this.
We haven't shared with the uh, like now we AAA Insolvency Professionals LLP has become institutional insolvency professional. So the law was notified on 28th of September 2022, and IBBI and IPA has uh, speedily implemented it, and we submitted our application. So they did the due diligence of all the partners of AAA Insolvency, and they granted us the registration number. First, the IPA granted us the registration number, and then the IBBI granted us the registration number. So therefore, AAA Insolvency Professionals LLP became the first institutional insolvency professional in India under the new law. And now it would be possible for uh, for the tribunals, for the adjudicating authority to appoint AAA Insolvency Professionals LLP as IRP, RP, liquidator, bankruptcy trustee, and it will be the duty of the AAA Insolvency to authorize one of their partner to oversee this case and to sign all the documents. So that's what is the blessings of the court, that we became the first one in the country to get this registration, and all our partners are ready to work as institutional insolvency professionals. So the blessings of all the audience, everyone is respected, and thank you very much. So it's like just our humble uh, pleasure that we wanted to share.
Thank you, everyone. Thank you so much.
Thank you, Ji. Thanks a lot.